Every beat dropped, every script penned, every brush stroke on a canvas. It all starts with an idea. But in today's fast paced digital world, how protected are these ideas, especially in Nigeria's booming creative industry? On Saturday, April 26, we marked World Intellectual Property Day, and this year's focus is on empowering creators and innovators. So we sat down with intellectual property and entertainment lawyer Olusheye Abogunrin, who breaks down the myths, the legal tools, and what every Nigerian creative needs to know about protecting their work. Here is what he had to say.
One of the very big misconception, Nigerians have about intellectual property rights is that it is automatic. They think once you have an idea, it means you have intellectual property protection, which is not true. An idea is not protected by intellectual property, or intellectual property law does not protect an idea. It is an idea that is expressed that is protected by intellectual property. So when an idea remains unexpressed, it is not protected by intellectual property. So I would say that's a big misconception about intellectual property. A simple way is get a watermark of whatever you've created, get a logo. You can then go ahead to go for your registrations. For example, if your work falls under copyright, you can register with the Nigerian Copyright Commission. If you have innovated something new, maybe a new way of doing things, you can get that patented. You can also trademark your brand name. That is the name that separates your brand from every other brand. So you can get that, trademarked. Copyright endures for the lifetime of the owner and 70 years after their death. Trademark endures for the first time, immediately you register, you get protection for 7 years, and then it's renewable. You can continue to renew, and each time you can renew for 14 years, right? While for patent enjoys protection for 20 years. After 20 years, it falls into the public domain, and everyone can pick it up and use. You need the consent of the copyright holder to use a copyrighted work, right? You need to seek permission. You don't just pick someone else's skill, labor, judgment, that has been expended on something, and you pick it up and you begin to use it. You need permission. You need to seek the consent of the person. You need to have an arrangement. Hey, I want to use your what you've created for this purpose, and if the person is willing, you get an agreement, and then you're fine. However, if it is not up to 70 years for a work that is protected by copyright, and anyone picks that work, and appropriates such work, it will amount to an infringement. So if any musician or any artist intends to use a work, they have to, find the right order, and then they go through a process called clearance. You clear the song with the right order. Sometimes the right order might not be the family or the actual creator. So it could be, for example, I think recently the catalogs of people like Saheed Osupa, Barrister were obtained by Sony Music, and that means that if I have to use any of those songs under those catalogs, I have to seek the permission from that organization and not from Saheed Osupa himself. So these are the issues, and these are the ways to go about things like that. Firstly, you can take a civil action, which is to seek damages, right? You can ask for an antopila order, and that's seizing the property. You can send a cease and desist letter. That's even customary. That's the first thing you do, asking the person to pull down whatever has been pulled up, and stop using the work, and clear the song or whatever work it is with you. And you can also take a criminal action, right? In some instances, copyright infringements are like theft. In some instances, it can be like theft, and in that instance, redress can be sought in the court of law, and a criminal action can be taken against. Compared to other countries, I think it's a work in progress for us. Um, just in 2022, the new Copyright Act was enacted, and some of the provisions, to an extent, are at par with the realities of the digital age now. And although we are still far behind, compared to countries like the US, the United Kingdom, and some other advanced countries where they have more effective laws. In fact, I think their laws are more proactive. They think about the future and the possibilities that can be, and they make laws, to affect or to challenge those problems even before they appear. The major issue has always been about catalog and not people accusing labels of not fulfilling their obligations under the contract. So I think it's usually about money, royalties unpaid, obligations that are not carried out by labels. So it has always been centered around. Recently, it has been centered around that. So I think that's the disputes. The first thing you want to do is to express whatever you've created, right? IP, intellectual property rights, are not automatic. Like I said, you have to ensure that you express it. You express the idea. So you don't just have an idea for something and you do not express it. So you get it expressed in a medium, right? Of course, something new, not something you copied or something. So it has to be something new. You get it expressed. That's the first step before you even think about having the protection under the law. So the next step would be to, if it's a copyrightable work, you can notify the NCC. That's the Nigerian Copyright Commission, of whatever you've created, and then you get a notification certificate to that effect, and that helps you. If there's a matter in court, someone challenges you and say, "Oh, you're not the creator," you can always bring that up and say, "Hey," and that will help you in court. Also, you should get a lawyer. Of course, have a lawyer friend. If you can't afford one, just have someone who you think is experienced in your industry. So before anything is copyrightable, it has to be new. It has to be, you must have expended skill, your labor and judgment on it, and it has to be fixed in a medium. So something as simple as sending a mail to you. Maybe you wrote a poem. Sending a mail containing that poem to yourself, allows you to enjoy copyright protection. So basically, musical works are copyrightable, literary works are copyrightable, artistic works are copyrightable, sound recordings are copyrightable, broadcasts, cinematograph films, so these are copyrightable works. But generally, for either of those works, you must have expressed them in a tangible medium. You must have expended your skill, labor, and judgment, and they must be new.
In a world where content is king, protection is power. And as we've heard, understanding intellectual property rights isn't just for lawyers, it is for every artist, musician, designer, and digital creator trying to make their mark. Whether you're dropping your first single or launching a fashion brand, the message is clear. Create smart, protect early, and know your rights. And as we celebrate World Intellectual Property Day, let's keep championing originality. You're watching eCentral.